Would like to welcome everyone to one of our editions of Deep Dive. We're going to be discussing the tribal gaming compacts and tribal gaming in general. Joining us via the interweb today is Judge Patrick Moore, and he's going to kind of help us with some insights into tribal gaming and its processes on approval and compacts and how that all that legal jargon that we often don't understand. He's going to help us with that. And then also joining me is my colleague, Gary Fife, a radio specialist. He's here with us in the studio this morning. Well, from his home studio, I guess. And he's going to be kind of coming in with some questions too. We have lots to be educated on when it comes to tribal gaming compacts. It is a very involved process. And good morning, Judge Moore. Thank you for making the time and sitting with us this morning as we get all the technical issues ironed out. And it's great that you made the time for us. Thank you. So just to kind of rock around along to get us started, I was hoping that Judge Moore, could you give us some insights into what gaming dollars does for tribes, just to kind of a broad general. I think a lot of people out there are thinking of the casinos as somebody's getting very rich, but in reality, many of the dollars collected from gaming operations in Oklahoma are going directly to citizen services. Can you kind of touch base on that relationship for us a little bit?
It's not only citizen services, but it's an industry now that's responsible for a lot of services to other people. Mm-hmm. It allows the tribes themselves to participate in things that if they did not have this money coming in, they wouldn't be able to do. All this really started when the Creek Nation built the bingo hall up on the Mackey Sandbar. And from there, it's developed into a major industry for the state of Oklahoma. And I think the way it's been handled up to this point has been all right, as far as I'm concerned. Recent negotiations and lawsuits have thrown a cloud on everything, and that shouldn't be happening.
Mm-hmm. Can you talk about that evolutionary period where it went from a, bingo hall into actual machine games where, the games weren't based so much on bingo, but this kind of developing phase, like what major events took place in our state at the federal level when we kind of started developing this industry?
Well, actually, back early on in the early 80s, before the National Indian Gaming Regulatory Act was passed, the Creek Nation had a bingo hall in Tulsa. There were numerous lawsuits that were engaged between the city of Tulsa and the Oklahoma Tax Commission and the Creek Nation. The end result was that the first case had to do with Tulsa and the state wanted to collect sales taxes on the income the Creek Nation was getting from their bingo hall. And that went all the way up to the 10th Circuit. The 10th Circuit ruled that that was not allowed by the state or the city. And as a matter of fact, there's a very critical thing in that particular decision of the 10th Circuit where they said the Mackey Sandbar is a special piece of land. It is original fee. In other words, it was part of the original fee deed that was given to the Creek Nation in 1856. And that's rare property. All the rest of the lands in Oklahoma basically have been deeded by a chief of the Creek Nation back to either a citizen of the Creek Nation as an allotment or to another individual by purchase or reserved for the tribe at that time. Mm-hmm. Then the next thing we had people, now bear in mind, this is all before the federal government got involved in protecting Indian tribal rights from other people. Mm-hmm. Then we had a company that came in from up in Minnesota. I think Minnesota or Michigan. It's been a long time ago, back in the 80s.
Mhm.
and they were running the bingo hall for the Creek Nation. There was a dispute at that time over expenses that were used by this company as applied against net income.
Mhm.
The tribe and the company didn't split the net income. The company in, I think it was Indian Country USA was that company. They got, I think, 40%, excuse me, and the tribe got the rest of it. But naturally, they wanted to take their 40% and all their expenses off of that before they got 40% of the net income. They wanted that deal. Well, that went to tribal court. And of course, they filed lawsuit in federal court saying the tribal court didn't have jurisdiction. The end result was that the federal judge ruled, yes, the tribal court did have jurisdiction. And then there were some other spin-off lawsuits that had to do with the money that was in a bank in Tulsa. I happened to be the guy that issued the order to seize the casino back early in the morning, and I cautioned the Light Horse Police that day, before you go to the casino, stop at the bank first and let them know that you're seizing the money. And the first thing that the Indian Country USA people did after the Light Horse went in to seize the bingo hall, not casino, is they ran to the bank, and by that time the bank had been notified that money was being claimed by the Creek Nation. That resulted in a lawsuit that went to the 10th Circuit, and the 10th Circuit Chief Justice Mvskoke said, well, that's jurisdiction of the Creek Nation Indian Tribe District Court. I don't have anything to do with that. And that settled that issue.
Mhm.
Then the lawsuit over all the money stayed in tribal court. I thought it was going to be over in a couple of days or a couple of weeks anyway. It went on for 7 years, but in the interim, I by order created a 40% permanent fund, which was later by the Speaker of the House converted over statutorily, and that resulted in the current permanent fund that the Creek Nation has. And then the lawsuits keep coming down whenever something happens. This is nothing new. Money attracts lawsuits for some reason. And they went from bingo hall to casino, but it was tribal gaming that they could do, which was not class 3 gaming.
Mhm.
And then we got into the class 3 gaming, which was the compact that you're all discussing today. And they really, I don't think, had any difficulties with that compact. And in the interim, of course, the National Indian Gaming Regulatory Act was passed and the federal government got involved in it. But that's a little bit of the history of the background of gambling in Oklahoma and gaming in Oklahoma, I might add.
Mhm. Can you talk a little bit about the relationship of the federal government in this process, the Indian Regulatory Act and the National Indian Gaming Commission, and how that, like, what is the relationship between the tribe and those federal entities?
Well, the federal government passed the National Indian Gaming Regulatory Act, and that placed all this gaming, whether it's class 1 or class 2 or class 3, the federal government has some say in how you operate that. And
Mhm.
the books are real thick now. By that time, there's one textbook that was written by Professor Rice at the University of Tulsa that I'm aware of. It's the only one I'm aware of that explains all the things that were done with respect to Indian gaming in the United States. Very
I
good.
have a couple of documents. I kind of wanted to fast forward a little bit in the like early 2000s, I believe it was under Governor Brad Henry, I think, when the current compact that we operate under today was kind of pinned, if you will, and those state leaders and tribal leaders got together. What is it, 2004, something like that, and they authored this compact, which I hear interchangeably used with the word contract. Can you specify how those are different?
Well, they passed they passed a model tribal gaming compact in the state of Oklahoma. And that was to allow Class 3 gaming. It didn't have anything really to do with Class 2 gaming. The state got no funds from that.
Mm-hmm.
And this was a long negotiation. It's a rather lengthy document that was signed finally by most of the tribes. The Creek Nation, I think, did it approximately 15 years ago, because it's supposedly to have expired on the 1st of this year, or didn't expire. And that's one of the things that's in litigation now in the federal court, is whether they just automatically renewed or not.
Mm-hmm. Yeah. When the compacts are formed, what is the relationship that they kind of create? This is kind of, we went from Class 2 gaming, where we didn't cut out a piece of money for the state, to Class 3, where we're cutting out a different amount of money, and that goes directly to the state. Can you talk about that relationship a little bit, like how that works?
The Class 3 gaming wasn't allowed until they had a compact.
Mm-hmm.
Creek Nation and Indian tribes didn't have to share any of the Class 2 money. Mm-hmm. But to get to Class 3, that's more like a real casino someplace. And of mm-hmm. course, they've made some adjustments to it over the years. But once the state of Oklahoma passed the compact legislation and it's signed by the government, then they had to negotiate the compact, and every Indian tribe that I'm aware of, now these comments I'm making are just my comments, mm-hmm. has to agree to the model tribal gaming compact, which is at state law. And then that's where we start running afoul of some of the things that have been happening recently.
Judge Moore, could you take a second here and kind of define the difference between Class 2 and Class 3 gaming?
Well, I wish everybody could do that. It's the difference between Class 2 gaming is more or less electronic bingo, and Class 3 is big gaming like you have in Las Vegas. That's basically the difference. But we used to have
table games, cards, dice, roulette.
Yes, all kinds of things. They bet on water running down the window. The real problem with that is the same thing that Professor Rice used to have on his test. One of his tests was the students at the law school needed to go through a casino in Oklahoma and tell him which games were Class 2 and which games were Class 3. And it's really difficult to do. They even have to have these machines tested to make sure they qualify as a Class 3 or Class 2. And then, of course, it's new. We got some more Class 3 gaming by an amendment to the compacts that was passed by the state of Oklahoma. And I think, I haven't been in a casino in years. I think they have table games and some card games now that are a little different than they were before. Before, you could have what looked like a card game or looked like a craps game, but it wasn't. It's based on bingo. A computer controlled everything. And I'm not an expert. I don't have anything at all about running a casino. They got high-powered people that do that stuff. I'm just a country lawyer.
Can you kind of give us like a little brief rundown of what you've observed as the current climate in Oklahoma as far as Indian gaming goes? Like, what are your observations that you've seen play out over this last year or so that we've kind of been following the story on? Can you kind of summarize that for us?
Well, I don't know if we can summarize much of anything. I just got a copy of the order of a federal judge on you're talking about the extension of the compact or not?
Yeah, I'm kind of talking about the situation where we saw the governor and he writes a letter to the editor and says, you tribes can all come and negotiate with me. We're going to renegotiate these compacts. And then the tribal, well, now we're in mediation is the current status of this kind of back and forth between the tribes and the governor, and we have United for Oklahoma, where the tribes have kind of gotten together over mutual interests. And the most recent headlines we've seen was about a week and a half ago when the governor held a press briefing and he performed what really looked like a signature compact for the Oto and Comanche tribes. And in exchange, they were promised, or maybe they weren't, I'm not sure, but the consensus was that for signing and leaving mediation, which they did, they would be obtaining 2 more casinos, these tribes that have signed this contract. Can you kind of, what are your thoughts on that scenario playing out? Does the governor have the unilateral authority to issue a tribal gaming compact?
No. That's
What
simple.
would, he just does not. I wanted to take a brief moment to share this document with everyone. I have a letter from, let's see, the House of Representatives Office of the Speaker, State of Oklahoma, Charles A. McCall, State Representative. And I'll put this up for our audience to kind of look at. I'm going to share my screen here if I can do this. I tested it out and it went a lot smoother, so we'll see. And that way everyone can kind of see here. And I will try to make this a little bigger. I'm going to get my page display going here. Full screen mode here. So this is the letter that the House of Representatives Charles A. McCall sent to Governor Stitt, and I just wanted to kind of show everybody this real quick. Regarding, and this was sent, I'm sorry, what? Okay. So official letterhead and everything. And it was issued on April 22nd, right? Pretty close to following this press conference where the governor and the Oto and Comanche signed their compact. And it zooms up too fast for me. I'm gonna have to get where I want to show folks.
Can you back it up a little?
Maybe that'll help. There we go. It says, regarding your assertion yesterday of a gaming agreement with 2 sovereign tribal nations, we feel it prudent to inform you of the legislative branch's position on actions taken by you in negotiating and signing these purported compacts. In short, we find these actions unauthorized by law and void without action by the Oklahoma legislature. Judge Moore, and the question I have for you really is just, what is the Oklahoma legislature's role in compact approval?
Well, number one, they have to approve the compacts. They wrote the law that set up the model tribal gaming compact. This is a deviation from that. The House is 100% correct.
So any kind of agreement that these tribes and the governor have entered
Wanting
into,
to change the compacts.
Mm-hmm.
And actually the one that's come out recently with the other 2 tribes has really reduces what's in the compact legislation. And it actually, as I remember, I read about it in the newspaper, and I've got the newspaper with me. They're going to allow these tribes to put casinos on land they don't even own or don't have any jurisdiction over. Well, that's the purview of the federal government. They'll determine whether or not a tribe has the right to put a casino on some land they do not own. And my answer to that is they're not going to approve it.
And what federal entity is that does that approval?
National Indian Gaming Commission.
So there's several steps beyond a governor.
Yeah, just because the state of Oklahoma approves a compact with an Indian tribe, that doesn't mean that's it.
Mm-hmm.
The federal government then has to approve it. They're a little more strict sometimes than the state.
It looks like there is more opposition coming from the state administration here. We just saw a letter popped up in response to the legislature's opinions here. Mike Hunter says essentially that he agrees, and that the official opinion sought by House and Senate says the governor lacks authority to enter into and bind the state to compacts with Indian tribes that authorize gaming activity prohibited by state law. So where does that leave the governor, then, do you think?
Well, who knows what a federal judge is going to do, but you all gave me a copy of this order today, and I've looked at it, and he's telling, the judge over there is telling the parties that they need to file some motions. He wants motions for summary judgment from both sides. However, there's a difference in this between the motion from the governor's side and the motions from the Indian side. The plaintiffs and interveners, which is the Cherokee, Chickasaw, Choctaw, Potawatomi, Mvskoke, Creek Nation, Quapaw, Delaware, blah, 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 all those tribes, they're allowed to file 2 motions, but the defendants can only file one motion. So the pressure's on them to come up with a really good motion, isn't it? They better do one that's good, or the judges, they got a problem in federal court. But they should never even gone to federal court. If you look at the compact says, I'm going to quote you from the compact. The compact shall automatically renew for successive additional 15-year terms, provided that within 180 days of the expiration of this compact or any renewal thereof, either the tribe or the state acting through its governor may request to renegotiate the terms of subsections A, E of Part 11 of this compact. I'm not aware of anybody made a request to negotiate. Somebody just said this is the way it's going to be. And that's not a negotiation, in my opinion.
Yeah,
That's
I think
my opinion.
Also, the
That
attorney
make any sense
general's
to anybody?
This letter has also been sent to the Secretary of the Interior saying that it, quote, undermines the credibility and honor of the state when engaging in these sensitive inter-sovereign relations. So it makes them look pretty bad there. Now, let me ask you, Judge Moore, do you see this as a divide and conquer tactic by the governor to break up the solidarity of the tribal stance?
I don't know what the reason behind the governor's office is in doing compact with 2 of these smaller tribes and giving them additional, I mean, they got a break. The Creek Nation to take their break in a second. Looks like to me they cut the percentages down, but they don't amount to the big money. The state would be after the big money. They're after the Chickasaws and the Choctaws, the Cherokees, and the Creek Nations. They're not after these little.
The press conference a couple of months ago had 37 tribes, I believe, standing together saying we need to do this and we're going to remain in a solidarity kind of position. Now, with these 2 tribes kind of making a deal with the governor, is that like a crack in the wall, so to speak?
Well, I don't think it's any kind of crack in the law. They don't amount to anything. It's the first time I've ever witnessed the tribes getting together and standing together. We used to have a representative in the United States Congress 25 years ago that said, if all the tribes will get together and tell me what they want, I'll see that it's passed. He knew none of them could get together. And finally, they've gotten together, and you have to have a united front. Hell, they've taken everything in the world away from the Creek Nation. They took from the Atlantic seaboard to Texas away from the Creek Nation.
Since we've mentioned the solidarity and standing, I wanted to take a moment and share with everyone a statement that the chief's office has provided with us. Jason Salzman, the press secretary for the Mvskoke Creek Nation, sent this over just before we kind of started filming here. And this statement says, this is from Chief Hill, while the Mvskoke Creek Nation respects the individual sovereignty of our fellow tribes to make decisions they feel is best for their citizens, we also recognize the strength and unity for the benefit of Indian country. We affirm that we are still united for Oklahoma and will continue to seek legal and equitable solutions in our compact negotiations. Furthermore, this administration agrees with the statements and communications released from both a State Attorney General Mike Hunter and Speaker Charles McCall concerning the compacts. So that's the statement from the Mvskoke Creek Nation's chief saying that he does stand by the United for Oklahoma and that we are going to remain a collective kind of entity for those interests in gaming. And he also is throwing his support to State Attorney General Mike Hunter, which Gary has kind of shared those comments with, and then Speaker Charles McCall from the House of Representatives, which I showed on the screen there. So the chief does agree with those. Do you want to leave us with any thoughts on what possibilities we can see going forward as we go through these negotiations? I know that the United for Oklahoma spokesman has said that the tribes are willing negotiators if there's something that we can get as an equal and equitable exchange. What are your thoughts, Judge Moore?
Well, number one, David Hill, I've known him since he came out here, and he's made a statement that's a fact. You got to stand together. And this is a very wonderful statement he's made. And I think that's what they need to do. They need to go ahead and take care of their business in the Western District, Federal District Court. Whatever the answer of that judge is, it'll be appealed by somebody, I'm sure. Nobody ever wants to give up. But I'm also curious that the Attorney General of Oklahoma is supposed to be the lawyer for Oklahoma, but that's not the lawyer in this case in federal court.
Yeah, can you kind of give us? Is that typical? Do you ever?
No,
see that?
I don't know. These big shots can do all kinds of things. As I said, I'm just old muggy guy.
Yeah, it's to me it looks like there's a lot of dissension in the state with the governor's actions. There's not very many people coming out full bore support behind him, and probably I would have to just speculate, so I can't really finish that thought.
He's trying to do a good job for all the citizens, you see. Mm-hmm. And we got other people in other governments that are doing things similar to this, and we're not accustomed to seeing those. But all I can tell you is that the Native Americans in the United States have never been treated fairly. They finally took all the land from the Creeks in the east and gave them Oklahoma and said, we're never going to bother you again. And the land went from roughly Arkansas to what is the border of Texas. Then we had a civil war and they took half of that back because they wanted to turn it into reservations. It's just one thing after another. And sometimes somebody just got to do what's right.
Mm-hmm. Do you think that the money that we invest in defending ourselves in these lawsuits, do you think that's an equitable investment for defending sovereignty?
Well, you have to defend yourself when people attack you, my gracious. And the difference today and in 1853 and 1900 is Creek Nation didn't have any money. They had to rely upon the Bureau of Indian Affairs to give them money, and they flat wouldn't even let the council of the Creek Nation vote or have a meeting after 1906, and that's travesty. Has been all along.
I kind of have just a personal kind of summary to this scenario is like you mentioned how land was taken and it was land here, then land there, and then they want half, and I see the same kind of trait carrying out now that the future has become money. They've taken the land and now they're after a bigger slice of the money. A bigger slice of the money is what it looks like from the outside looking in. And people tend to forget that many of those dollars are distributed to these rural country schools that don't get adequately funded any other way. County roads that people ignore and aren't very high on priority. The Mvskoke Creek Nation works to pave those. And so I just wanted to kind of, do you see any scenario playing out where we lose? Like, is it dependent upon this judge? And I know that that's hard to kind of guess, but is there a point where the tribe could lose ground in what we've gained?
Well, I certainly hope not. It's about time that they got to keep what's theirs, really. That's my opinion.
Well, I think that's all the questions I have. Gary, do you have anything else for Judge Moore?
Do you have any feel for how this court battle may result? Say if it goes the governor's way, what happens? And if it goes in favor of the tribes who are contesting it, what happens there?
Well, it shouldn't be a contest. It should be a negotiation. That's the way the compact's set up. The Creek Nation can always just go back to Class 2 gaming, and all these other tribes can too. And then $150 million to $200 million is lost to school kids of Oklahoma. That's what it boils down to. And I think they just need to sit down at the table. And if they're going to do a negotiation, do it fairly, out in the open, let everybody know what's going on, and it can be resolved. But you don't resolve things with lawsuits. That's just my opinion. Things don't get settled at the courthouse. They need to be settled privately.
Thank you, Judge Moore.
Thank you.
Thanks so much.